Hello and welcome to another Let's Talk IP, and today we're sitting with David Spohr again. I'm sure some of you would remember him from a previous video about intellectual property and employment and how those two intertwine. And there's quite a lot of questions we get, I think, from both sides, where people don't understand the integrities of firstly intellectual property and then employment and then the combination and how those two work together. But before we go, again, subscribe and do all the necessary stuff like subscribe, share, follow the links, and David will say a bit more about himself. I think that let's start with that for people that didn't see the other video.
Right.
Yeah.
Okay, so I'm an employment lawyer. I've been since about 1998 when I was admitted. I've always specialized in employment law. Prior to that, I worked as a consultant from 1992. Been about 31 years in employment law, industrial relations, and still involved in it. That's it. That's what I have.
Yeah. So having worked with David on a few things, he's the Yoda of employment law, in my view at least. Yeah. So, with employment, and I think where we can start is a question that we get a lot, or no, I'm not going to say a question, a misconception that a lot of our clients sometimes have is the fact that, firstly, the statement is something like, yeah, but I created it. Isn't it then mine where they created it while they were employed? And on the other side, no, but they were employed by me and made it, therefore it's our company's. And it's not a straightforward answer. And unfortunately, Uncle Google has the wrong answer, and people look and watch American sitcoms and think what happens in that legal drama, which is drama, is how the law is actually applied, and it's not how it is. And don't Google this, please. You'll get American and foreign law.
Correct.
Law is specific to territories, to jurisdictions is the legal term. So, and the main principle in intellectual property is IP will be that of the employer if the employee creates it through the course of his employment. That's the important aspect here. And again, this is a general rule, and there's contractual implications and ways around it and things like that. But I think we can start with that. What exactly does that mean? Through the course of employment.
Okay, so what it means, and there's been in South Africa a number of court cases about it, and if you look at it from the IP perspective, if the employer employs the employee in a particular position and provides him with tools and training, expertise in order to develop some form of intellectual property for the employer, then that is done in the course and scope of their employment with the employer. So they're acting in the best interests of the employer. And in that respect, that IP that has been created then belongs to the employer. But it's not that easy with employment law. Because employment law is based on fairness and based on a contract of employment, which means that if you look at it from an employee perspective, he actually can take the knowledge that he's gained from his employer and go somewhere else and apply it.
Yes.
And that has happened and does still happen in South Africa's legal milieu. It does occur. There was many years ago a case of Siemens versus Reddy, which will give you a good example of what happened. Is Mr. Reddy was employed by Siemens, and apparently very, very clever with the new cellular technology at that time coming out, and he developed sort of a technology whilst working for Siemens that had great application for the entire cellular industry and would be used worldwide. And Nokia came to hear about this. So they came to Mr. Reddy and made him an offer he couldn't refuse, and he went to Nokia. Now, from an IP perspective, that's protectable.
Yes.
From a contractual perspective in a labor dispute, it's not.
Yes.
And luckily, Siemens had a restraint of trade at that stage. And to clear up another misconception, restraints of trade are enforceable. It depends on what they say. They are judged according to fairness. And if you do it correctly, they can be enforced, which is what happened in Mr. Reddy's case. So Siemens went to court and said Nokia cannot use his knowledge, and they won the case based on that. But that was because they had a contract in place to protect them.
An effective contract. That's
correct, yeah.
That's the thing, yeah.
Yeah. That restraint of trade was quite wide and broad, and was capable of being narrowed down to the particular knowledge that he had gained with Siemens to be used by Nokia, which they would then use against Siemens and I suppose other competitors too. And that portion was based on a contractual relationship between them. And that's why it's important if you work in a field where IP is something which comes with it, like in engineering, for instance, and even advertising, that kind of thing, and there's a large amount of intellectual property that is used. It's vitally important from an employment law perspective to have contracts in place which protect you as the employer against, I suppose, unscrupulous employees from making use of the knowledge and experience and the technology or whatever it is that they create, and then going to a competitor.
No, definitely. And you touched on that NDA. I mean, the amount of NDAs we see, like you said, the NDA comes down to fairness.
Correct.
Yes, to have an NDA in place is one thing, but to be able to enforce it is another thing. And at the end of the day, what is fairness? It's a very difficult area to gauge, and what is fair in one industry is not necessarily fair in another industry, and what is fair for one position is not necessarily fair for another position. Right. Technically, you can't prevent somebody from doing what he does for a living, but you can prevent him from applying certain skills and knowledge which was trade secrets, for argument's sake, at a new competitor, a competitive edge and things. And also, fairness can come down in an NDA to a geographical area. Correct. Again, not a set in stone aspect and a time frame. And there's a lot of things to consider and between, firstly, labor relation, what is fair in labor, correct, and what is the legal principles in this discussion now relating to intellectual property. And those two laws need to be harmonized and argued. And, well, the argument is always who's got the better argument. And again, and we always say this, you have to go to somebody that knows the intricacies of the laws. In this case, you need to go to somebody that understands and knows and specializes in intellectual property, as well as somebody that does employment when you deal with this. You can't just go to a general practitioner. And look, we love general practitioners. They've got their place. And a lot of the work we do and you do stems from work of a general practitioner. But these are specialists and extremely specialist fields that you can't just wing. Correct. That's the thing.
And there's a number of intricacies in that field that you need to take account of. You know, if you look at the application field for restraints of trade, for instance, it's been so narrowed down that there's only particular elements of that work that an employee does for you that you can restrain them from using against you with a competitor. You know, a good example would be if an employee gains knowledge whilst working with you and you train him and teach him how to work, that can be restrained. But if you hire an employee who is already trained and already knowledgeable, you can't restrain him from using that knowledge going forward. No. I was involved with a case a couple of years ago, which had at heart of it was hydraulics with large mining pumps and agricultural pumps and the taps that were used in order to open those and close those. Now, the person whom I represented was a hydraulics engineer by trade, by training. He'd been appointed by a particular company as hydraulics engineer, and he had sort of sold their stuff and helped to develop further technology whilst with them, but using knowledge he already had. So he then moved on to a competitor, offered him a better package, and they tried to restrain him. And our argument was, you can't restrain me from stuff that I knew when I got to you. Exactly. And we won the case on that basis. The same, for instance, you know, if you look at IP, the periods under which you can hold a person bound by the intellectual property regulations and laws
Yes.
is different to, say, restraints. So
Yes.
the courts aren't all that, in labour, not very keen to extend restraints of trade for long periods. And recently there was a case reported where it was they allowed it for 3 years.
Which is...
That is extreme.
Yeah.
Usually they want 12 months they're happy with. And there was specific circumstances in that it was 3 years. And if you've developed intellectual property making use of an employee, you don't want just 3 years of usage of it. You know, if it's a brand that you've created or something like that, you're expecting a long-term usage out of that.
Yeah, and that's a big thing to also, it brings me to a point where there's a difference. Yes, they are related, but there's a difference between the employment aspect and the intellectual aspect, as well as the restraint versus the intellectual property law and rights. If you as a engineer, for argument's sake, have a restraint for 12 months, let's argue that it's a fair restraint. For 12 months, you're not allowed to go to a competitor. Month 13, you go to a competitor. And you create the same or a similar product than what you created for your previous employer.
Right.
Yes, you're outside of the restraint. But if the ex-employer registered a patent on this development, and a patent is valid if it's a valid patent for 20 years, yes, you're out of the restraint, but you're infringing the registered patent.
Correct.
So great, they can't nail you on a restraint.
Or the employment aspect of it. Yeah.
But there's the intellectual property aspect. The one does not automatically exclude the other. And again, you need to understand the difference and speak to people with the difference. Yes, you're out of the restraint, but that development might have intellectual property that has other laws and other time frames involved with it. Designs are 10, 15 years depending on the type. A patent is 20 years. Trademarks, if you developed a brand, that trademark is an indefinite right as long as it is renewed.
Yeah.
Restraint is 12 months, 9 months, argument's sake. So understand the difference, understand where your rights lie and where the one stops and the other one begins. But again, understand your rights.
Yeah.
Nothing prevents you from doing a similar job. Just don't infringe, don't steal. That's the main thing. And that question comes up so often, and it unfortunately is something that you can't explain over the phone and quickly and explain because no, this is what's happening. We need to see the agreements and the contracts and look into the contract, argue fairness, advise on it, and then look into the intellectual property, like we just made a distinction between the two. What's the implications thereof?
Yeah.
Do you think it's worth developing the same thing for another guy? And I mean, that's just the first element of this, is that restraint and employment on that. What comes when you create something for somebody else? Literally, and now we're going to the creation. I created this product for we established, if you create something through the course of your employment, meaning I was employed to create these types of thing, therefore I created it, it is the ownership of the employer. Again, through course of employment, it's very important to note you need to be employed.
Correct. Yeah.
There's various methods and ways within, but it needs to be employed. It's not a commission. It's not I ask somebody to create something for me that's not an employee. There's other aspects. There's assignments that needs to be done to ensure that the IP is transferred and things like that. We're not discussing that now because that's a discussion that's completely different. That will take another hour or two. But if I create something not through the course of my employment, but while I was employed, that's something else.
Yes.
If I create, I am employed as an engineer, but all of a sudden I wrote this amazing song. It's not my company's, it's mine. And a company can't claim ownership into that because you were employed by them. Subject to a lot of aspects, please, we're just generalizing now because there might be contracts, you might be a sound engineer, and there's a lot of areas, but in general, if it was not through the course of your employment,
correct,
and you did not use the company resources, that's also a very important thing to note. It's not by default that of the employers. But there's a lot of gray area there.
And a fantastic example of that is a guy called Adrian Gore and a guy called Barry Schwartzberg, who worked for Liberty Life in the 1980s and 1990s. And Liberty Life, that stage, is a life insurance company. And in about 1991, 1992, in their own time, they came up with this fantastic plan for a medical aid. So they went to their bosses and said, we've come up with this fantastic idea of how to create a medical aid that will cost nothing and that places the duty of negotiating price on the consumer, and there's a medical savings account in this, and we can give people gym. And Liberty said, well, this is not our core business, guys. I mean, why are you wasting your time developing this? Okay, and Adrian Gore and Barry Schwartzberg went and created Discovery. We all know
the rest is history.
and the rest is history. So that was IP that they created in their own time, not using company resources, and then they went and tried to give it to the employer and said, we've built this thing, and the employer's attitude was,
no, it's not what we want.
We're a life insurance company.
Yeah.
Leave the medical aids to those people who did it. And I think they're probably trying to bite themselves between the eyes right now. But that is the kind of thing that can occur. So if you go and you build something in your own time, that's outside the course and scope of your employment.
No, it is. But again, it's very important to understand what outside the course of your employment is. It's not as simple and straightforward. And like I mean, this example David just mentioned, both of them are insurance.
Yes.
But it's not the same. It's outside of the scope. It's again in their own time, not using company resources, and it's not related to each other.
Correct.
And when I say not related to each other, I mean on a legal principle.
Correct. Yeah.
Yes, insurance is insurance, and to the layman they might be related. Yeah. But you have to consider the industry and the product or the solution or the creation when you do this. And again, the reason we say this is firstly to give some information, but also to let people and let the viewers understand that it is a complex scenario.
Correct. Yeah.
Like all of these fields are. There's a reason specialist attorneys exist, and you need to understand it. Please don't try and figure it out yourself.
It's worthwhile seeing the specialist ahead of time. You know, it's different than to doctors. When you get sick, you see the doctor.
Yeah.
With us, you make that risk analysis, and part of it is getting legal analysis ahead of time, so you don't end up in 2 million and 10 million rand litigation 5 years down the line.
Rather have a discussion with an expert that costs you a few hundred, a few thousand rand, than go and litigate. IP is high court litigation. And it's easily going up to, especially if it's corporate companies against each other, it's a $1 million up for litigation.
And you spend 5 years, 6 years.
It's not like you see on TV. Court cases takes years, and it's back and forth, and it's expensive, and you're not guaranteed that you're going to going to win, or even if you win, that you make your money back. It's not a by default you win, pay their legal fees. There's a lot of other implications. So before you take the gamble, just speak to somebody, speak to us, speak to David. And we work together quite often on these things, and we as specialists understand where our expertise end and where we need to bring somebody in. And like you see now from the discussion, it's employment law and IP is important factors. But the layman, and again, nothing against general practitioners, they might not understand that and how they are intertwined and where you have to look at the things to look at. And again, and I think I'm speaking here to our fellow general practitioners. Contact us. We are able to assist you and your clients without wanting to take your clients, because if you want to deal with your clients, we're happy. And we're not only experts, please, there's a lot of experts. But the fact is, it's so complicated and complex, and you have to understand these areas and to know how to navigate it. And on both sides, it's not just for the employee; it's for the employer as well.
Yeah.
How do you go about ensuring that when the things are created, like the Liberty case, put it around if the correct contract, not restraint, but contractual obligations on intellectual property clauses who were in place, they might have had a different case.
Correct. Yeah.
I don't know who their attorneys were, but
Yeah.
that might have been a consideration when contractual, employment contracts were drafted. Intellectual property within the scope of employment belongs to the
And you
employer.
would expect that, given that both of the people were actuaries, they're
Yes.
not necessarily at a high level of management, but they're at a high level of skills and specialization. That if you're hiring people like that, that you make sure that on some level, whatever they produce is bound back to come to you.
Yeah,
and that you can protect it.
Put an intellectual property clause in,
Yeah.
apart from the restraint, because like we discussed, the restraint and intellectual property, although they are related, are vastly different with different applications. And it's so important to get that right beforehand. It's like insurance. You get insurance before you crash your car. Good luck getting it after you crashed. Nobody's going to do it. And same with intellectual property. If the same. You can't try and fix it after the fact. It's not going to happen.
Yeah.
So, and another thing sorry to interrupt, but another thing to take into consideration when it comes to intellectual property is there's a time frame in place on when you can protect it. Trademarks anytime, but patents and designs, you need to protect it before it's public.
So once it becomes public.
Yeah, definitely don't try and do that afterwards. And there's no way around it. Don't think there's a loophole. There isn't. If it's public, and public is very, very broad, it's no protection, and it's worldwide. Trademarks work on a different scenario, and there's similar things in employment.
Correct. I mean, if your restraint is 9 months and you don't enforce it within the 9 months, you've lost it. Yeah. And the same would go for if you had a confidentiality clause or intellectual property protection clause. Once the contract's terminated, if you don't have a clause in there that says it's in perpetuity, then you lose that employment law-wise.
Yeah.
You don't have that anymore because the contract is now cancelled.
No.
If you as an employer do something to get an employee to be dismissed and it turns out at the CCMA it was an unfair dismissal, that's the end of your contract.
Yes.
You can't enforce a contract then because you've breached it by treating the employee unfairly.
Yeah. It's that we actually see often on the intellectual property clauses, where but he created that at his new employer, and the contract says why. Okay, but a contract was ended. You can't enforce a contract that has been cancelled unless there's clauses that stipulate and things like that. But did you register the intellectual property? Because yes, you can't enforce it, but now they might be in breach of registered intellectual property.
So there was a case in about 2006, 2007, which involved, I think, Old Mutual. And what it said, the finding went to the Supreme Court of Appeal. And what the judiciary said was that in terms of our constitution, all employees are entitled to fair treatment or fair labour practices. And what they then did is they interpreted that as changing common law in contracts of employment to say all contracts of employment need to be fair, and if it treats a person unfairly, that's a breach of the contract. And I was involved in a case just a couple of years afterwards where the employee was dismissed, and then the employer tried to enforce the restraint of trade. But the dismissal case got to court before
the restraint.
So the CCMA held that the dismissal was unfair. And we then supplemented our papers to say, look, the CCMA has made the finding it's unfair, it was an unfair termination, thus the employer has breached the contract. It is the normal contract law principle. If you're in breach of the contract, you can't enforce its terms. And we won the case on that basis.
Yeah.
So if you're going to fire your employee unfairly, don't expect to be.
Yeah, that is a very important thing. Don't try and enforce a contract which was found to be unfair, or they were cancelled because of unfair practice. It's so important to just talk to people before you do, before you act. Just discuss it, and then do what you want. But at least you've got the entire scenario put out. Yes. No, and I think we can go on with this discussion forever. But for the sake of the viewers, we won't. So we can always have a part 2 and part 3 later. But
we're going into philosophy of
but a philosophy we're going to need wine and whiskey and
there we go.
I think we can do that. So again, thank you for watching Let's Talk IP. and labor. And if you've got any questions, reach out to us. Reach out to David. Again, you can reach out to us and we'll put you in contact with David. It's not a problem. He is one of the consultants at a firm. And we look forward to hearing from you and to engaging with you further and just sharing some insight into the vast areas of law. And this is just two of the areas. There's so many to elaborate on and have discussions with experts in those fields. So, thank you for watching.
Thanks for having me.